A very good afternoon to all. We would like to extend a very warm welcome to our audience attending this webinar on the key legal challenges being faced by businesses in India. Thank you for taking the time to be with us today. Before we start, I take this opportunity to firstly wish you all safety and health and express gratitude to how fortunate we are to be able to discuss and analyze the situation we are in today due to COVID-19 and its implications from the safety of our homes. We are also fortunate in having with us a very distinguished panel whom I will introduce shortly. To give a brief overview to what we will be discussing today, businesses, whether it be small scale SMEs or behemoths or large enterprises, have had to face various challenges even pre-COVID, be it uncertainty due to policy changes, overruling of long settled precedents by the judiciary, delay in dispensation of justice, ambiguity in taxation provisions, multiple level compliances, supply chain issues, labor issues, etc. Post-COVID and the lockdown, these challenges have become manifold at a much faster pace than any of the businesses could have predicted. Today, we propose to highlight the key legal challenges being faced by businesses in India today, and more importantly, the way forward. We are delighted to have stalwarts from the in-house legal community who lead their diverse teams across regions and industries and constantly innovate to provide business solutions to their group. I would now like to introduce you to these esteemed panelists who will give their valuable insights for today's discussion. I'll first introduce Mr. Dev Bajpai. He's the Executive Director, Legal and Corporate Affairs and Company Secretary, Hindustan Unilever Limited. He has been a member of the Management Committee of HUL since May 2010 and was inducted on the Board of Directors of HUL as a full-time director with effect from January 2017. He's a fellow member of the Institute of Company Secretaries of India and has a law degree from the University of Delhi. He completed an executive program for corporate counsels at Harvard conducted by Harvard Law School and has 30 years of experience in diverse industries that include automobiles, FMCG, hospitality, and private equity in the areas of legal, governance, tax, and corporate affairs. He has been part of committee of apex industry organizations such as CII and FICCI. He has also represented the industry before parliamentary committees. Now I introduce Dr. Sanjeev Gimawat. He's the Executive Director, Legal and Group Company Secretary, Dalmia Bharat Group. Dr. Gimawat is a General Counsel and Corporate Secretary and also a Chartered Secretary from UK, a Chartered Accountant and a Cost and Management Accountant. He has almost 3 decades of experience spanning varied industries, working as Executive Director, Legal and Group Company Secretary with Dalmia Bharat Group. He is also an acclaimed speaker, author on varied contemporary legal and industry-specific issues. And presently, he is the co-chairman of the Law and Justice Committee of PHDCCI. He has now been acknowledged and honored as one of India's finest in-house counsels, the most influential corporate counsel and company secretary, and also inducted to Global Hall of Fame for contribution and work in the legal ecosystem in India and the world. I now introduce Mr. Mukesh Namba, who is the Senior Vice President Legal with DLF Cyber City Developers Limited. He completed his Bachelor of Law from Delhi University and has thereafter attained a rich experience of more than 20 years in the areas of corporate laws advisory, litigation, commercial matters, capital market, intellectual property, corporate restructuring and compliances. He started his career under pupillage of Mr. Harish Salve, Senior Advocate, and later moved to the corporate world and has a vast experience in telecom, infrastructure, and real estate retail sectors. He has been actively giving lectures and is visiting faculty of various academic institutions, professional and law colleges in India and abroad. He regularly speaks on arbitration, corporate restructuring, compliances, and legal reforms. He has represented the industry on various forums and actively participated in the legislative consultative process. He has been a part of the legal committee of ASSOCHAM, PhD Chambers of Commerce, FICCI, and Gurgaon Chambers of Commerce. I now introduce Mr. Khaitan, who is a senior partner of Khaitan Co. Company. He heads the firm's corporate M&A and private equity practice. He is consistently ranked as India's top corporate lawyer. Aside from his involvement in several high-profile and complex M&A and private equity transactions. His expertise is sought after by some of the most prominent private equity funds, hedge funds, financial sponsors, boards, and corporates, as well as some of the largest global investors investing in India. He serves as an independent non-executive director on the board of directors of several Indian public listed companies. And finally, I am Mrs. Vanita Bhargav, partner in the dispute resolution practice of Khaitan Co, Delhi, and an advocate on record in the Supreme Court. I have experience in a variety of matters, including matters relating to constitutional laws, taxation laws, environmental laws, civil laws, corporate laws, and mining laws. Before I hand over, let me briefly explain the format and housekeeping rules. This webinar has been set up as an interactive session. You can submit questions online at any time during the webinar and in the Q&A session at the end. We would request you to keep the instructions clear with you handy. Hegri will first cover an outline of the key issues that have been relevant for corporate India these days. This will be followed by a panel discussion where we will invite our panelists to share their views and experiences and their outlook for the future with us. This will be followed by a Q&A session, which will provide you with an opportunity to raise issues of importance to you. To submit a question, simply use the facility provided in the webinar portal. We will endeavor to answer as many questions as we can. If we cannot answer all your questions in the Q&A session, we will be happy to do so offline by email. Now I would request Haigreve to commence the presentation.
Thank you, Vanita. So I'll just start right away. You know, what is corporate India and Indian business really facing? So what we're really seeing is contracts, inability to source and pay, slippages, impediments on exports, imports, tax issues. We are seeing employment issues, how to really deal with work from home issues, social distancing, how do we deal with pay cuts, layoffs, what are the legal issues coming, financing. This whole lockdown and COVID has led to debt defaults, pressures on cash flows, RBI, what is RBI, the concessions RBI is granted, what are banks doing, and finally around governance. You know, we've got a lot of relaxations from MC and SEBI. What are some of the constraints corporate India and companies are facing, and some of the opportunities as well. And finally, I think Vanita will speak around some of the litigation experience. So with that, I'll start with contracts and force majeure. You know, any contract, parties to the contract must comply with their obligations. And any non-compliance of obligations by the parties to the contract leads to breach of the contract. And that breach can lead to damages, a claim for indemnity if the contract so provides, specific performance, injunction, and of course reputational damage. So when can a party really be excused from performing the contract and yet not be liable for any of these consequences? So one of those is this concept of force majeure. The concept of force majeure comes from the French term force majeure, which means superior force. So as the term itself indicates, if a party is unable to perform its obligations because of a superior force or for reasons beyond its control, then a party may be excused from all of these consequences of non-performance. So when is this actually available? This is available if the contract itself has a force majeure clause, and without the contract itself having a force majeure clause, this relief from performance is not available. Assuming there is a force majeure clause, one has to actually check the language of the clause, whether the event in this case, the pandemic or epidemic or the inability to perform because of government action or orders is actually covered within the language of the force majeure clause. And if it is, then does that event actually prevent the performance of the obligations, or the performance of the obligations are can't be actually done for reasons other than these events? And lastly, has the party done its best to mitigate the impact? So if all of these tests sort of yes, then a claim to get relief under the force majeure clause is possible. We'll take some examples. Some clauses are wide and inclusive in contract. For example, where a contract says force majeure means any event including acts of God or such other events beyond the reasonable control of and attributable to the affected party. Now, this is quite broad, and in such an event, a force majeure can be claimed because even though the word pandemic, epidemic is not covered, the clause is very broad. Let's take another example, which is an inclusive example, and where the clause says force majeure means lightning, earthquake, tempest, cyclone, flood, volcanic eruptions, war, strikes, and all other events beyond the reasonable control of and not attributable to the affected party. So while here there are specific events, there is a catch-all provision, and the catch-all provision will again give relief when one can claim force majeure. Then there are other examples where a clause can be exhaustive, and here it is definitely available where it says force majeure shall mean war, armed conflict, flood, terrorist act, storm, tornado, natural disaster, fire, and act of God. So while the clause is specific, question will be whether this epidemic or pandemic is an act of God, because in any of the other uh, uh, stipulations are not met. So if it is not an act of God, one cannot claim force majeure under such a clause. So to summarize, it really depends on the clause, and it depends on the language of the clause as to whether or not an event is covered. So we'll take some examples, and let's take examples for this lockout and whether or not it is actually covered. Say, let's take a contract for a sale of goods where there may be an obligation to ship, and where the goods have been dispatched and shipped, but not yet arrived at the port. The question is whether or not a buyer can claim force majeure. So one has to again see the terms of the contract. If the terms of the contract are CIF FOB, then the title and risk has passed. And even if there is force majeure and a buyer cannot unload the goods from the port, title and risk is passed, and it's no good to claim force majeure. The buyer will still be liable. It is the buyer's goods, and the risk of clearing the goods, taking delivery, is on the buyer. Another example of, say, commercial hardship and inconvenience. So if there's a contract for, say, supply of vegetables, and then there is pandemic or government order, the guidelines and the order actually exempt essential goods and services, and let's assume a buyer doesn't want to actually take delivery. Is it force majeure or not? Can one claim? Let's assume for the goods, the prices gone up or down, or one has inability to pay. So inability to pay itself cannot be ground for force majeure. That commercial hardship is not a reason where one can claim force majeure. So before one actually invokes force majeure, one should be aware of the consequences. So one should read the clause carefully, whether or not one can claim, and then see whether or not one would have liability to claim, and then claim force majeure. So some of the practical tips and strategies: follow the procedure laid out in the contract, be specific. Most contracts will have a specific process for giving force majeure notices, a timeline, see whether or not you're covered by the clause, see whether the other party's obligations are also impacted by force majeure. So if both parties' obligations are impacted, then both will claim force majeure. It may not serve any purpose. Perhaps take legal advice. You might be required to give actual proof. See if there are other practical ways to resolve the problem. Sometimes one is entitled to claim force majeure, but with a long-term supplier, with a long-term buyer, it may or may not be commercially prudent to invoke force majeure. So look at other conciliatory methods as well. And then, of course, correspond very carefully. We'll move to another part of force majeure. What happens to contracts where there is no force majeure clause? What does one do there? And one has inability to perform because of this pandemic or because of the lockout. So under our Contract Act, there is a concept called frustration. And what it provides is that if it is impossible or illegal to perform an act under a contract, then that obligation need not be performed. The contract becomes void or can be terminated. So unlike force majeure, where the obligations of a party are in suspension, and while it is in suspension, the contract is not yet terminated unless the contract so actually provides. In the case of frustration, you cannot choose to remain in the contract. The contract stands terminated or is void, so it is not something which is in suspension. Also, if you claim frustration, the counterparty may seek restitution. If you are unsuccessful in the frustration claim, you might be liable for damages. So this is again something needs to be thought out carefully before invoking. One aspect coming up on force majeure is under real estate contracts and live-in licenses and leases. And what happens in this case? Of course, we are going to hear Manish later today, and his expert views. Nobody better than Manish to tell us. But just in terms of the law, if there is a lease, then the Contract Act doesn't apply. The Transfer of Property Act applies. And unless the lease itself has a force majeure clause, the Transfer of Property Act gives very little relief. The Transfer of Property Act will give relief only when a property is damaged or destroyed. And unless a property is damaged or destroyed, one cannot come out of the lease under the provisions of the Transfer of Property Act. If it's a leave or license, then again, the frustration principle under the Contract Act will be available. And in both cases, of course, the terms of the lease or license, if they have a force majeure clause, one will be able to see. Many cases have come to us over the last few weeks as to whether or not I can stop paying rent. The first question is, look at the lease deed. If the lease deed actually says that if even if you have pandemic mentioned, even if you have epidemic mentioned, many lease deeds we've seen says if because of the force majeure event, the property is destroyed or the property is damaged, then you can claim force majeure. So even while the event is covered, it is not damage or destruction, and therefore you can't actually claim force majeure and stop payment of rent. Similarly, if you're the landlord, it's in your favor and you can continue to collect rent because this is not an event of force majeure. Relevant to real estate, under the relevant RERA provisions, again, there is a force majeure clause under statute. State governments have been given the power to actually notify. Many state governments like Maharashtra, Karnataka, Tamil Nadu have notified this pandemic and lockout to be a force majeure event, and in which case one would get additional time and without penalty time to deliver and complete and deliver the project. Similarly, under the STPI, laws, governments have actually waived rents for a period in time. So that completes the contract section, and I'll move the next section for discussion, that is insurance. A lot of questions have come to us as to whether or not this event and the loss caused due to this event or pandemic or the government orders can be claimed under insurance. The simple answer is look at your coverage, look at your wording of the policy, and if you have a business interruption risk policy, most business interruption risk policies cover 12 risks, and they do not cover pandemics and epidemics. They do not cover government orders, and there is a specific exclusion. It is unlikely that your business interruption risk policy would cover loss of profit, loss of opportunity, but yes, one has to go back to the policy and see the coverage before deciding whether or not there is any claim under the business interruption policy. Some other issues to look at your policy. There are several riders, there are several policy terms. One has to read the fine print before deciding whether or not to make any claim under the insurance policy. There are exclusions such as material damage being caused is a carve out under the policy. For premises, policies usually have a provision that if it is unoccupied for over 30 days, there's a lapse of the policy. So even though you may not claim under the present business interruption, you have to go back and see whether the existing policies for other risks such as fire is still valid or not, because those policies may no longer be valid because of the unoccupied 30-day provision. And then look at policies like the health and medical policy. We've again seen so many health and medical policies which have complete carve-outs for epidemic diseases, and then one is not able to claim. Of course, IRDA is coming with guidelines, and there may be a stipulation from IRDA on health and medical policies to honor COVID-19 claims. But as a matter of the policy itself, it's important to check your group and other policies. With that, I'll move to the next section of the presentation, and that is really around workplace and employment. A very important issue, troubling all of us, both in our capacity as employers, helping legal departments in our own companies, helping management, and also in another way as employees ourselves. So what is really happening? Work from home. How do you really implement the work from home policy effectively? How do you ensure compliance? What are some of the practical issues coming? Some of the practical issues coming is around data security, confidentiality, privileged information. How do you really provide all of the IT support? How do you prevent data theft, leak? There have been lots of articles around the press around this, and for all of this, companies and businesses will be liable. So if any of this actually happens as work from home, and that results in a loss to your customer or to counterparties, companies will be liable. So it is very important that while it's very easy to say that yes, we'll all work from home, to relook at the policy and to really see what are the risks and how to mitigate some of the risks around work from home. While on the same subject, temporary shutdown, how do we navigate this temporary shutdown? How do we really see that whether we have to pay, whether we have to actually lay off, we can lay off or not? How do we manage the workforce and expenses? How do we really plan around whether we grant leave, whether it's unpaid leave? And during this period, while business is coming back and some establishments have been allowed to function, what policies we put in place for social distancing, sanitization, transportation. Because for all of this, companies and senior management and people responsible will be responsible. We will be responsible for the health and safety of our people. And then to the last section, that if the lockdown continues, what are the considerations? What do we do with new joiners? If offers are there, can we terminate the offers? If the joining date hasn't happened, there is a view that yes, you can actually rescind and terminate those offers. Practically, of course, companies are adopting the policy of definitely delaying those joining. How do you engage with unions and workforce for coming back to work? A lot of our labor and employees have gone back to their respective states. How do you get them back? What do you do in terms of reviewing wage bills? How do you really plan extended layoff closures? And these are some of the issues being faced by corporate India. So while we deal with these issues, what are really some of the legal provisions? So in terms of managing workforce expenses, one could actually think of holding back non-essential payouts and allowances. Most government, state, and under the Disaster Management Act have issued guidances not to cut pay. But in terms of incentives, discretionary payouts, there's no ambiguity. Those can definitely be cut. Whether or not temporarily wage cuts can be done, whether or not one can force somebody to take paid leave is a question. While these orders have been passed, the validity of these orders, the legal enforceabilities of these orders under the Disaster Management Act are in question. Except for some states, local states have not passed orders which are binding under the relevant labor laws. Dealing with contract labor, again, what are the safeguards for principal employers? Of course, as a practical matter, if there is any reduction, companies would first look at contract labor, terminate those contracts. And of course, the obligation to pay contract labor under these orders also stands. And then monitoring compliance. So can one take disciplinary action? Can one actually enforce compliance? Yes, one can do that. One has to be practical in these times, because how do you really get somebody to come to work if you can't provide safe passage, if you can't provide the infrastructure for work from home? So these are some practical considerations one will have to have and bear in mind before actually enforcing the letter and spirit of the law. Some of these advisories, questions have been asked whether or not they are legally binding. As you may be aware, some cases have gone to the Bombay High Court, some cases have gone to Kerala, and now the Supreme Court is also seized and clubbed 4 or 5 matters and issued notice to the government on whether or not these orders are binding. And it seems that the correct view is that obviously companies and employers can't be forced under the Disaster Management Act to actually continue with employment, keep paying, and one has to really follow the relevant provisions of the relevant labor laws. But we will finally see what the Supreme Court actually decides. For managerial and other workforce, practically speaking, there is a negotiation happening, there's an agreement, and bilaterally, most businesses and companies are cutting pay, but on consensual terms. And obviously, everybody's taking a view that businesses have to survive. And if businesses themselves don't survive, then the question of employment remaining is itself a question mark. We'll move to the next section, and that is around financing and debt. One very good question, whether or not one can claim force majeure under debt and financing documents. Can one claim doctrine of frustration? The answer is no. Most financing documents would not give borrowers the right to claim force majeure. If at all there would be provisions for the lender's benefit, then the lender need not disburse if certain events have taken place. Commercial difficulty on payments, commercial difficulty on interest servicing cannot be reasons to get out of financing commitments. One has to also look at cross-default provisions under finance documents. And of course, we have had MOF communication not to impose penalties if instruments are not stamped within 30 days. They've given 30 days after lockdown lifting. Some of the RBI reliefs, the moratorium periods, 3 months moratorium on installments and interest, the relaxation on not declaring SMA NPA, which has really helped companies and businesses. Questions have arisen that, look, interest will still need to be paid during this moratorium period. Obviously, since it's a moratorium, a question of levying penal interest doesn't arise. Under the IBC resolution plan, times have been extended by 90 days, and for NBFCs as well, relaxation has been given for 1 year for CRE projects. Under the Insolvency Code, the default threshold has been increased for anybody going to NCLT by 1 crore, and of course, power has been given to suspend IBC, which has not yet been done. And there is a lot of talk in the media as to whether IBCs will be suspended for a period in time. Again, some practical insights. We are seeing lenders canceling commitment facilities, lot of renegotiation happening at this point in time. Carve-outs are being negotiated for material adverse effects. New financing documents which are being put in place for bridge finance. Borrowers are careful that they don't really default the very next day after borrowing. Everybody is exploring cost cutting, shoring up liquidity, evaluating concession and interest rates, and also availing the emergency credit line, which some PSU lenders are actually providing. Some more critical considerations from a financing perspective. Watch out for if you are the borrower for conversion clauses. Watch out for triggers on account of pledge and promoter guarantees, appointment of nominee directors, and of course, disclosing as willful defaulter. Then moving on to the next section around investment agreements, very much like other contracts, one has to look at the contracts themselves. I'm mindful of time, so I'll be quick here. One has to look at the material adverse effect and material adverse change clauses. Mostly these clauses would not given out, they would be carved out for non-business specific events. Most MAE clauses would be specific to the very business one is contracting for, and general industry development, policy changes, government changes, epidemics, natural calamities, acts of God would usually be excluded from MAE clauses. And then one would also look at for listed companies that yes, the falling share prices may be attractive for creeping acquisitions, for delisting offers. At the same time, in some cases, one has to watch out that this may be a time for hostile acquisitions. Around corporate governance, a lot of general relaxations given, and for the first time, we've seen that even general meetings can be done by video conferencing or other audio-visual means. A very welcome change. A lot of extensions given for all meetings being held. CAROR applicability has been extended by a year. Filing dates have been extended. Board meeting dates have been extended. Again, SEBI has also extended dates for filing. So a very welcome relief. and one must compliment our regulators for acting so quickly, swiftly, and every representation being made to the government is looking at it seriously and acting exceedingly fast to grant relief. So with that, I'll really hand over to my partner Vanita, and she will take us through how the judiciary is responding to these times, and the judiciary, what sort of cases it's entertaining, and what orders they are passing. So over to you, Vanita.
Thank you, Haigreve. So the COVID-19, can we have the slide? Yes. The COVID-19 pandemic has disrupted the justice delivery system like never before. The compulsions associated with social distancing, coupled with lockdown directives, have led courts and tribunals to shut their premises to the public. At the same time, recognizing that a complete shutdown of the justice delivery system is undesirable, judicial administrators have embraced technology to meet the challenges posed by the pandemic. Currently, Supreme Court, various high courts, district courts, and tribunals have made an adaptation to hearing cases through video conferencing, albeit in only urgent matters. Today, one can see what the effect on society and economy is if justice system comes to a halt, as it has in COVID-19 times. It causes great hardships to the legal system, practitioners, and mainly to the litigants. Speedy justice and resolution of commercial disputes is essential for business. Protection of fundamental rights is also an important field that should not remain suspended due to disruptions of the kind we are facing currently. The Honorable Supreme Court, in its order of 6th April 2020, has held that access to justice is fundamental to preserve rule of law and democracy. So video conferencing is not a matter of discretion but of duty. It has also been recorded that ICT infrastructure is available across all courts, including judiciary, which is quite commendable. In the future, as we cannot rule out some other kind of disruption, all stakeholders, government, judiciary, lawyers, and clients should prepare themselves to adapt to virtual courts post-COVID as well. While conduct of some arbitrations and recording evidence through video conferencing is taking place, virtual mediation and virtual court post-COVID needs to be given a push. Subject to overcoming certain challenges to make this a reality, this will surely help in saving costs, transcend geographical barriers, save time, and speed up delivery of justice. The judiciary has responded well to tackle some of the pressing issues that litigants faced, like how will litigants file proceedings, especially in cases where the limitation period is expiring. What if a client requires urgent release from the court? With social distancing restrictions, how will courts operate? Will courts protect those genuinely affected by COVID-19? So as far as limitation issue is concerned, Supreme Court led the way with an extraordinary order of 23rd March 2020, extending the period of limitation for all proceedings. This was both an unprecedented as well as a bold move. This provided much needed relief to litigants who were concerned about limitation issues. Though court premises are closed, almost all courts across India have put in place a system which allows parties to file proceedings and apply for urgent reliefs. E-filing is largely possible and hearings are being organized over video conferencing facilities. The system of mentioning matters for urgent listing now requires an urgent request to be sent to the competent authority, and acceptance or refusal is informed through mail. There is no option of mentioning before the honorable judges through telephone as was allowed prior to 15th April 2020. In the long run, if this practice is followed, this will save a lot of time for the judges. While several high courts across India were holding urgent hearings via video conferencing, on 6th April 2020, the Supreme Court passed directions for conduct of court proceedings across the country via video conferencing during the period of outbreak. And after the nationwide lockdown was imposed, the Apex Court has heard 583 matters and delivered judgments in 215 of them in a month. Following the order of the Supreme Court, various high courts, including some of the lesser spoken about high courts, have issued guidelines for holding hearings via VC. The Delhi High Court has also expanded sphere of hearing of matters through video conferencing to pending matters falling under certain categories, including petitions under Section 9 and 34 of the Arbitration Act. In my recent personal experience where I appeared for a client in the Supreme Court, we did face certain technical glitches in e-filing due to overload of system where many people were trying to upload their files at the same time. There was also the challenge to scan numerous documents, especially with the office shut. The hearing before the Supreme Court, however, went smoothly. There was a test run conducted prior to the hearing. The communication through WhatsApp with the control room created by the Supreme Court eased solving of queries. The attention and patience one got from the Supreme Court was also more than one can expect on a normal miscellaneous day. The Honorable CGI has recently made a statement that video conferencing proceedings are here to stay. Going forward, therefore, litigants, in order to adapt to a virtual court hearing system, essentially need to be prepared by doing the following. Digitization of record pertaining to all transactions and dealings be maintained so that if and when any dispute arises and one has to approach courts, time is saved in scanning documents. Most of the corporates are already following this system. Going forward, this should be adopted as a uniform policy. Investment in IT infrastructure and a dedicated IT department can quickly fix technological glitches, and it has become the need of hour. Investment in security software that prevents hacking and leak of our confidential documents is also very essential. It is also important to have digital signatures in place. Investment in high-speed internet so as to become a part of virtual conferences with seniors and a virtual court hearing is also essential. In case of a company as a client, it would be helpful to have the board resolution authorization letters in place with a scanned copy stored, and the same goes for the wakalatnama. The companies have to understand that going forward, they can expect changes in timelines due to e-filings, results of court proceedings, and have to tune in their expectations accordingly. The legislature and courts have to iron out technical glitches, protect confidentiality, and increase access to justice, and adopt means that enable open courts. That is a constitutional necessity. May I have the next slide, please? So we'll just look at some of the cases how the Delhi High Court, Bombay High Court have issued protective interim measures or orders largely on equitable grounds. So in the case of Anantraj versus Yes Bank, the Delhi High Court held that the RBI advisory issued on moratorium on loans in the wake of COVID-19 pandemic is applicable even to loans which were on default as on 1st March 2020. The Delhi High Court held that the bank should not have classified a loan account as NPA when delay in payment of installments was caused due to COVID-19. Similarly, in the case of Transcon Iconica Private Limited, the Bombay High Court, while keeping alive the issue of maintainability of a writ petition filed by a petitioner against it being declared an NPA on account of default in payment post 1st March 2020, granted interim relief by excluding the period of lockdown for computation of 90-day NPA declaration period. Then in Ashwini Mehra versus IOCL, Delhi High Court has restrained IOCL from invoking or encashing bank guarantees furnished by the petitioner. Similarly, in the case of Halliburton Offshore Services Inc., the Delhi High Court passed an interim order staying the invocation of 8 bank guarantees in light of the present times. However, in a recent case of Indrajit Power Private Limited, Delhi High Court dismissed the petition to refrain center from invoking bank guarantee. In the case of Eastman Auto and Power Limited versus RBI, the High Court passed an interim order of no coercive action against the petitioner for the default committed by it in the reverse factoring facility, intended to provide working capital to the MSMEs who have made supplies to the petitioner and raised invoices on the petitioner, default of which would have entailed penal consequences. However, in some cases like Standard Retail versus GS Global, the Bombay High Court refused to grant exemption under the force majeure clause to steel importers. So all of the above are interim orders, and it is to be seen on the facts of each case and the respective contracts how the jurisprudence around COVID-19 cases unfolds. Whether judgments will be passed on the basis of equity will depend on the facts of each case. Tribunals are also largely functioning on the same lines. However, for NCLAT, we have had to make physical appearances at great risk and steps need to be taken to provide for video conferencing facility in NCLAT as well. The National Company Law Tribunals across India, though physically closed, are prepared to hear urgent matters via video conferencing facilities. In Quinn Logistics, NCLAT directed that for all cases in which CIRP has been initiated and is pending before any bench, the NCLT or NCLAT, the period of lockdown as ordered, be extended in the area in which the registered office of the corporate director is, would be excluded for the purpose of determining the outer limit of 330 days. As for pending matters, NCLAT and NCLTs have suo motu extended interim and protective orders. Although there are challenges being faced by the judiciary in the smooth functioning, and going forward, there is a scope of improvement if virtual hearing is to form part of our system post-COVID, it is heartening to see the efforts put in by the judiciary and stories of how chief justices are traveling by road from one state to another to take charge, which is inspiring and encourages all of us to forge ahead and meet the challenges faced by us during these times. Thank you. So with that, we come to an end of our presentation. And I will now call upon our esteemed panelists to shed their valuable insights to the issue. So starting with Mr. Dev Bajpai. Dev, so the first question, the challenges faced by the FMCG sector during the lockdown would have been quite different from those faced by other sectors which had to deal with complete closure of business. So what were the challenges faced by HUL in catering to the essential services list, considering supply chain disruptions, ensuring social distancing and transport restrictions, and how did you navigate through them, especially in the light of different notifications applicable in
Thank you, Vanita. Good afternoon, everyone. These are unprecedented times, and FMCG industries has impacted, if not more, as compared to any other industry. Even though our portfolio largely falls under groceries and essential goods, as has been notified by various orders passed by the Ministry of Home Affairs, but there have been significant challenges, and the FMCG industry has been significantly disrupted in this quarter. I must add, though, that the central government and also the state governments have worked with great speed and for very long hours, because you can see the speed with which the notifications and the orders from MHA have been coming, and the corresponding notifications and orders that are being passed by the state governments, because they need to pass their notification once a guidance from center comes. And talking about FMCG, yes, because we cater to the common man for her or his daily needs. Many of our products, as I said, fall under essentials. So to that extent, we are slightly better placed than the rest. But we have prioritized within our portfolio. As far as HUL is concerned, it has been our effort and endeavor to ensure that we ramp up our supplies of sanitizers, hand washes, body washes, cleaning products, hygiene products, and foods and refreshments. And we have deprioritized some parts of our portfolios like makeup, cosmetics, etc., because these are not, the need of the hour. And we have, as far as the essentials is concerned, that is where we are, and that's what has been our endeavor. But coming to the challenges that you talked about, yes, these are practical challenges on the ground, whether it is with respect to movement of people, movement of goods, how to maintain social distancing norms. These are all practical challenges, and we have been working very closely with the state government, with the state administration, with the state capitals, with the state secretariats, with the district administration, and also with the central government. It might look seemingly, conflicting that at one stage the government wants that more and more essential goods should reach the market. On the other, there are restrictions on movement of people and movement of goods, more so on movement of people. But it is quite understandable that government is also trying to ensure that while goods reach the consumers, at the same time the hygiene and social distancing norms are met. So we've been at it, we follow some of the best processes on social distancing. The processes in our factories are best in class. In every permission that we seek from the government, we have been telling them that please come and inspect our premises to see what are the social distancing norms we are following. And many of them have come, and it gives immense confidence to them. So therefore, our offering this and their coming helps the cause. I firmly believe that industry has to play an important role in ensuring that this rightful objective of the government is met, and we have to partner and collaborate with the government, and it will then help the government to ease up things. So there are challenges, there are problems. Interstate movement of labor is a problem. Many of our factories are on the borders. So some of our factories are in Dadra and Nagar Haveli, and workers come from Gujarat. But there is a challenge to get workers from Gujarat to come into BNH. So we have had problems of those kind, but we have agreed to work with limited manpower, prioritizing our portfolio, which is required today more than it ever was as compared to some other items. And we are working with the government on this and hoping that things will ease up as we get going.
Thank you. Thank you, Dev. Dr. Gimawat, so I wanted to ask, you've had almost 3 decades of experience across varied industries, and your role at Dalmia Bharat Group covers a conglomerate which operates in sectors such as cement, sugar, refractories, and power businesses. Given the wide ambit of operations of the group, where were you most immediately impacted, and how did you respond to the altered business and operational requirements of COVID?
Thank you, Vanita. So first, good afternoon, friends. Mr. Hagriv, Khaitan, and Vanita, thank you very much for the enriching presentation and also inviting me to share my views. Thanks a lot for that. Now, regarding your specific question in terms of the impact, how this whole issue unfolded, my thought is that, and before coming to the specific industry issue, never ever in the history of mankind we have experienced this kind of situation. As far as our generation is concerned, the most nearest experience which we have is of 2008. But then this 2008 experience and 2020 experience is significantly different. In 2008, we were at the before the recession. We were in a very high economic growth kind of situation, and not only India, almost all countries of the world. But in 2020, we are already suffering from a serious slowdown, serious unemployment problem, and in that backdrop, this situation came up. Now, this situation has come all of a sudden. Nobody expected that, and because of this sudden nature of this issue, this has created a havoc in the system, and havoc is in twofold. And in fact, not only my industry, in fact, all industries throughout the world has suffered. And this havoc was in twofold in terms of the health crisis as well as the economic crisis. And it happened in almost all countries, all jurisdictions, and all organizations. Even I was listening there. He is from the essential commodities kind of industry. But still, despite that, despite the fact that his industry was allowed to operate, he faced problems. But then forget about the situation with regard to those industries which were not allowed to operate, and all of a sudden the livelihood has gone. All of a sudden the people were asked to leave the premises. And just think about the situation of 4 crore people who are the migrant labor. That 4 crore people is a size, a population size of many countries. Now, in that backdrop, we were facing this problem. The interesting part is, ILO reports suggest that nearly 80% workforce, global 80% workforce, which is somewhere around, say 300 crores kind of people, they got fully or partially impacted. Now think about the Indian situation. Indian situation is, and where in the industry in which we work, largely, if you notice that we are coming from a large industry, for example, sugar or cement or coal or steel or many other real estate, etc. But the fact remains that the support which is provided to this industry is from the MSME sector. And the MSME sector itself is a 7.5 crores kind of entities with 12 crores kind of population. Now 12 crore population of employees, they are without job. The data suggests that if this continues, the 40%, over 40% MSME sector would be over. So it essentially means all those people would be unemployed. Now, in this backdrop, we are facing the situation as far as our industry is concerned. So the immediate crisis which we all industries have faced is in terms of taking care of our employees, taking care of safeguarding the interest and safety of the people. So that was the immediate issue which we all faced, including Dave or Manish or some, any industry. If you ask, the same issue we all industries have faced. And the second important aspect was the kind of advisories and circulars which got issued. And of course, there was some certain amount of chaos in terms of understanding those advisories and circulars initially. But then after a point, this was understood and comprehended by people. So coupled with this, as Mr. Khaitan explained, in terms of force majeure notices, in terms of communications from various suppliers, vendors, etc., you keep on having these kinds of communications, and which keeps you completely busy. And the fact is, nobody in today's world would be interested in litigation. So effectively, all industries suffered on all three accounts, which is manpower, material, and money. And all these three accounts led to one, manpower in terms of fear, in terms of operations. Even in sectors where the industries have been allowed to operate, there was a fear. There was a fear in terms of workers joining the plant. Even the villagers were asking them not to go because there was a serious fear and apprehension that he would perhaps impact, impact the other villagers. From a materialist standpoint, because MSME sector was not functioning, because global supply got disrupted, it was a serious supply disruption. And liquidity, as we all know, liquidity was a major problem. It was earlier also, and it continued also. Now, in that backdrop, we have all responded. The important thing is, in 1 month's time, the kind of experience, in 1 month's time, the kind of maturity which all stakeholders, and I mean it, all stakeholders, they have expressed and showed, it's tremendous. The kind of collaboration between industry and government which happened in 1 month's period, it's an example in itself. Now I think, from that perspective, I think we have all acted with maturity. We have all taken care of each other, and perhaps in the times to come, the things would certainly improve. And if suppose the same momentum goes, I have no doubt in my mind that we would revive, and we would revive absolutely superb. So this is what my brief comment on the whole issue is. One more comment I would say that the acceptance of reality in such a short period of time never ever happened. 30 days period, just think about it, 30 days period, acceptance of reality and people acting and responding to that issue never ever happened. Thanks.
True, Dr. Gemawat. So it's heartening to know that the government is collaborating, from what we gather from what Dave and Dr. Gemawat has said. Coming to you, Manish, your role at a premier real estate company who pretty much invented Gurgaon, developed Gurgaon city as we see it today, and one of the largest owners of commercial and residential real estate in the country, must have encountered some interesting situations on account of the lockdown. The burning topic is whether lease rentals are payable by businesses during disruptions caused by pandemic and consequent government-enforced lockdown. Without directing the question to any particular use of any particular company, what is your take on invocation of force majeure clauses by tenants of malls, etc.? Do you think that in context of force majeure, the parties will resort to negotiation or take the contention route? Like Dr. Gemawat mentioned that people will stay away from litigation. And how do you foresee the contracts being any different in the future?
Vinita, the word COVID-19 may be new, but pandemics are not new to the human civilization. A historic record shows that pandemics were there even 5,000 years ago. And one of the first pandemics which I could find out in the history books dates back to 5000 BC.
and that should be something around about in China itself, because some mass graves were assumed, and it was found that they would have died because of pandemic. And as it is said that those who do not learn from history are bound to repeat it. Even the word force majeure may be of French origin, but it was there even before the concept was there in the Roman law, even before France as a country existed, or maybe French as a language as we hear it today. So therefore, this concept, unfortunately or unfortunately, my task has been made easier by the presentation of Agriv. He has outlined what it means and what it does not mean. Force majeure is not a concept which is the word as such recognized under the Indian Contract Act. Coming to leases, now this is a big elephant in the room because everybody is either a lessee or a lessor, and the manner in which we do business today. The answer has been given by Hegreeve. I need not dilate on it, that you need not look into the Contract Act or the Transfer of Property Act. You need to look at your own contract. So therefore, without going into the specifics of the issue, most of the contracts would not have a force majeure clause. If you don't have a force majeure clause, too bad for it. The law as it stands today does not give you that kind of a reprieve unless a situation arises under 56 and you say that everything has been frustrated. That is a long shot. Historically, the last 400 years of English jurisprudence, 70 years of Indian jurisprudence shows that it is very difficult to enforce and say that a force majeure situation under 56 has arisen. So therefore, each one will have to look at each individual contracts. Merely because the expression force majeure has been used in the lease deed or in any contract does not give you much of a right. You need to, the devil is in the detail. You need to understand what are the consequences of that force majeure if and when it were to arise. Very easy to allege, very difficult to prove. In case of a pandemic, it may not be very difficult to prove, but the mere fact that there is a pandemic does not mean that it would encompass and cover in your lease deeds. So therefore, ensure that whether or not the expression pandemic or epidemic has been used in your lease deeds. Having said so, that may not be enough. You would see what are the consequences provided. In most of the leases, where you will see that it would be provided that it would be either the physical damage or destruction of property. Unless there is a physical damage or destruction of the property, most of the lessees, unfortunately or fortunately, would not be able to get the benefit. Similarly, insofar as business disruption clauses are concerned, they may or may not cover insofar as these clauses of force majeure are concerned. As Agreed said, I also read it in the newspaper. GIC says that their entire exposure on account of this COVID-19 would not be more than 35 crores. That means you are neither contractually covered nor are you covered under the under the provisions of a force majeure under your contract. You may be very lucky if your contract is so loosely worded or so greatly worded and you had the benefit of the hindsight, as it was in one of the deals where they say that pandemic will not be considered or will be considered, as in today's newspaper in one of the deals which happened for one of the uh, uh, brands, where they said that this will not be considered. Not everybody would have had that kind of a foresight, and therefore in most of the cases I would say this benefit would not be available. Having said so, look at your lease again, consult your lawyer before shooting a force majeure letter. think think means think twice. It may also provide that if that situation continues for an X number of days, then both the parties will have the right to exit out of the contract. If that be so, then the remedy may be even worse than the disease itself. And if your lease gets terminated, think of those consequences. As it has been said by Sanjeev and Agreev itself, it is better to look at your contract, look at the entire situation holistically, completely, calmly, take a decision in a business-like manner. It is very easy to start litigation, very difficult to end it. It may be more painful, and therefore it is necessary that before you act, you think twice, take sane legal advice. before you jump into this bandwagon of just issuing notices. The second issue which you have raised is that whether or not the contracts of the future are going to be different. Yes, they are going to be different. There are two ways they are going to be different. By that time, I do understand there would be policies for insurance which will be available. Once those policies are if such a situation would arise, neither the lessee nor the lessor should bear the brunt of this kind of a situation. It must be passed on to insurance companies and business must be made out of it, rather than lawyers and commercial people arguing endlessly to death, stating that this would be the position. We should very quickly work upon a situation where we have insurance policies covering that, and the tenants and the landlords, as the case may be, may not mind paying 10 paisa per square feet extra, rather than fighting out these cases in the courts. So thing is, in most of the cases, lessees will not get that benefit. They need to be extra lucky if such a clause is there. If the clause is there, good luck to them. If it is not there, go to a good lawyer, read your clauses, and even if it is there, think before you shoot notices, think the overall situation, and ultimately a good settlement would always be better than a good win in the court. That's how I see this proposition. Thank you.
Thank you, Manish. That's a fair point. Dave, coming to you, you've already said that you took steps for prioritizing the sectors, the products in which manufacture should commence. But what was your initial reaction to when the news from Italy and Iran, that started pouring in? And like Dr. Gimawat said, we had very little time to react. So, what was your initial reaction to COVID-19? And if, in hindsight, would you approach this differently if, God forbid, such a situation looms again?
So look, being part of Unilever, sense of what was going to come, because we have a big business in China, and China, is also supplier of a lot of materials to our other businesses across the world. So we had some sense of what's going to happen. We prepared for it. We kind of took steps before WHO declared this as a pandemic. We basically started work from home much earlier. It was around 16th or 17th of March. And we were very clear on what were the 5 or 6 main areas or imperatives which will drive our strategy during this period. It was people, it was supply, it was demand, it was community, and finally it was cost and cost. Essentially 5 of them. People were stopped. There was no compromise on that. There isn't one at all. The safety and security and well-being of our people remains a top priority, and we are working towards that. The second was supply, and we had to ensure end-to-end supply across our factories, to the depots, to the warehouses, to the distribution centers, and to the front end. So ensuring end-to-end supply was important. Demand, during these unprecedented times, the demand pattern shift. There is a shift in consumer demand. New things come up. Today we find there's a huge demand for cleaning and hygiene products. So everyone wants to, focus a lot more on cleaning and hygiene than they ever were. So that's the other one. Community, we were one of the first companies that committed 100 crores towards community work. We reduced the prices of our hand washes. Sanitizers came under essential commodity, so prices were regulated. But even before they could come under Essential Commodity Act, we had reduced the prices of sanitizers. We did likewise for our hand wash category. We've been supporting a lot of hospitals across the country, including the top ones in Mumbai like Kasturba, Seven Hills, with a lot of products, soaps, sanitizers, kits, PPEs. We have also set up quarantine facilities in and around some of the towns and close to some of our factories where we are called upon to do at very short notice. And we are doing a lot of work on building awareness on this whole thing. So that community comes was also very important. And cost and cash, because cash is king when you have less. And even though we are a debt-free company, but conserving cash and ensuring that we reduce costs and we are judicious about the costs. This is something that we've been doing. We continue to do. I don't think we would have looked at, doing anything differently, because these are pretty much the priorities. And everywhere there is a learning from what you go through, and this is an ever-evolving situation. It is changing by the day. You have containment zones, you come out of them, there are new containment zones. We have almost 70 manufacturing facilities in India, including 29 of our own factories. And we've been, the legal team, along with the supply chain and customer development team, has been working very hard to see that we are able to unlock supply chain and our sales. And it's, as I said, it's an evolving situation, something where you get some permissions and then you come back because there's been some case or there's been some outbreak. So we are learning as we go. We are making a lot of constructive suggestions to the government. We are taking feedback and giving feedback to them. So I would pretty much pivot around these 5 priorities that we have set for ourselves. These are the right ones, and we will do everything to continue to serve our consumers.
Thank you. So, Dr. Ghimawat, there has been some ambiguity, like you mentioned that there has been ambiguity between the MHA circulars and the state circulars. So, one of the ambiguity that comes to mind is that all sectors are categorized as a continuous process, and even different states took a different view from the MHA guidelines. For example, Orissa permitted limestone mining only if it was used in steel manufacturing. The contradiction between state notifications and MHA guidelines has thrown up certain challenges. What, according to you, are the key challenges faced by the cement and infrastructure sector in general? And what are the challenges that you see that the infrastructure sector will face in the future, both in the immediate future and in the midterm?
Vanita, multiple questions in this one question, but then let me respond to this. First, to answer your main question, that key challenges faced by cement or infrastructure sector as far as due to COVID situation. My immediate comment would be that due to COVID, this can simply be understood by the data released by the government yesterday. Out of the 8 core industries in the infrastructure sector, 8 core industries, there's a negative growth during the last month, which has never happened. It's a 6.5% negative growth. And if you take example of the cement sector is nearly negative 25%, around 25% of negative growth. So this is what the kind of situation we are in, that as regards the 8 core sectors are concerned, there is a negative growth. So that itself conveys this. Now, as regards your specific question in terms of continuous process or the ambiguity as far as notifications are concerned, now I believe that there was no ambiguity initially, yes, but then thereafter, once these issues got understood, there was no ambiguity. And let me give you example. As regards all notifications or circulars were issued by not only the MHA but by various state governments. They were issued either under the Disaster Management Act or the Epidemic Diseases Act. Now, if you take the Disaster Management Act, it's a 3-tier structure. In the 3-tier structure, it's a top-down approach where center has powers, state has powers, and even district administration has powers. The only difference is that district administration would not be issuing any circular or directions or guidelines, or the state would not be doing that, which is contrary to what center has issued. So they can always issue over and above what center has already issued. That cannot be a contrary view. So this is what various states have given advisories and directions and guidelines, but then largely they are oriented towards the MHA guidelines only. Now, as regards to a specific question as far as the steel industry is concerned, or where the limestone mining is permitted, the fact is, as far as the continuous process is concerned, steel is a continuous process. So is the cement industry. It's a continuous process. So there is no ambiguity as far as the continuous process is concerned, or the industry's nature is concerned. The only thing is, in the case of steel, you have no option but to, perhaps that was the reason why the Odisha government has issued that, because unlike the cement plant, which is the integrated plants where the mining operations are together with the plant operations, in steel plants this is not the situation. The steel manufacturing is different and limestone extraction is different, and that is the reason why they have specified as far as the steel industry is concerned, that yes, limestone extraction for as far as steel is concerned, that is allowed. So this is from that context. It does not mean that the limestone extraction was not permitted as far as cement sector is concerned, or it is not a continuous process. So there is no ambiguity on this as far as this whole legal framework is concerned. Now coming to the immediate future or the infrastructure sector, the challenges, etc., I would say there is no doubt, no dispute that infrastructure is key to the driver. There is no doubt about it. Everybody accepts this, whether COVID or without COVID. The fact is that poor infrastructure would never bring economic growth. There is no doubt about it. Now, as regards the challenges is concerned, or the immediate future term is concerned, or midterm plan is concerned, or a specific question on this, my take is the economic survey of 2020 was very clear when it says that, when it sets the objective of a $5 trillion economy by 2025, it has allocated $1.4 trillion for the infrastructure sector. So that $1.4 trillion, it's over 100 lakh crores rupees between 2020 to 2025. Now, if we stick to this very plan, if we stick to this plan of $1.4 trillion of investment in infrastructure, there is no reason why we cannot achieve the $5 trillion economy. There is no reason. But the fact is, who would be bringing this money? Now, as regards the national infrastructure pipeline is concerned, which is already provided in the economic survey, under the national infrastructure pipeline, out of this fund, this whole requirement of $1.4 trillion of investment between 2020 to 2025, the 39% is required to be brought by central government, 39% by the state government, and the remaining 22% is by the private sector. Now, the difficulty here is, neither central government has money, nor state governments have money, and private sector, just forget about it. The private sector is not in a position to invest 22,000 lakh crores of rupees in this sector. So who would be bringing this sector? The objectives are clear. The national infrastructure pipeline is clear in terms of allocation of funding also, whether that be roads, bridges, railways, etc. Everything is clear. But then to bring the modern technology, to bring the funding, somebody will have to bring that. And to that extent, we are facing a challenge. So from a private sector standpoint, if you ask me, that I think there is a need for a systemic changes on that, and systemic changes also if you want to bring money from the outside world, because modern technology or funding, foreign investor would not be investing in India unless we make those systemic changes. And the systemic changes, the biggest important systemic change which I foresee is that we need to create an environment. We need to create an environment whereby people can invest money, not only foreign investors, even the domestic investors. And I will just give you, because from the time standpoint, perhaps we are over time, just one sentence, and which would convey you everything. On last 15th August 2019, Prime Minister Independence Day speech said, used a few words, and which are very, very important. What he said is, respect wealth creators. That respect for wealth creators, unless you bring that respect in the Indian industry, you cannot attract investors. Forget about domestic, foreign, forget about foreign. The domestic investors would also not be investing money. So this is what the systemic change we need to bring in, and the systemic change also requires those legal and regulatory kind of changes. The legal and regulatory kind of changes also in terms of enforcement of contracts. Just think about the situation on ease of doing business. We are at 63rd. We have brought down significantly. But as far as the enforcement of contracts are concerned, we are still at 161, 163. And why? The simple logic and simple rationale is that the Indian justice delivery system, you did mention in terms of your presentation that whether the courts would be deciding this on equity and all that. Why equity in a commercial arrangement? Why in a commercial understanding between two commercially prudent minds and prudent parties? legally prudent parties. Why you are invoking equity? Why you are invoking 142? So there is no need to bring these issues as far as commercial issues are concerned. And perhaps there you would be creating that kind of environment that people would be giving credence to your contracts. People would be giving credence to your commercial arrangement. So this is one change which we need, immediately. And the second change, which I think that would be required, is the change in the mindset of the bureaucracy. Bureaucracy's mindset is profit making itself is bad. I think that mindset needs to be changed. I don't get surprised when I see the report that the young IRS officials have prepared a report whereby they were, talking about rich and poor and taxing rich. Now, this is the mindset. I think that all these mindsets are discouraging. So that's it. Thank you. Thank you.
Thank you. Manish, very quickly, so how do you foresee the supply and demand in this commercial and residential real estate sectors? Do you think there will be a slump in the demand, especially commercial space, considering the costs involved, and many sectors being in a recovery mode may adopt work from home as a regular feature rather than an aberration?
This is more a commercial and an economic question than a legal question. But I don't think so insofar as we are going to change, but we are not going to revolutionize in our behavior and things of that nature. I don't think so. The physical infrastructure will go. While there may be a requirement from work from home, this may over a period of time increase. There is, because of social distancing, the workspaces which were used to be at one point of time 100 square feet have come down to 75. You never know, they will go to 150 square feet, meaning thereby there will be demand for space. And I'm very hopeful this pandemic, when it gets over, we will do better than the rest. And India and China, probably, or third Indonesia, are the only three economies which are expected to grow at 1 or 2%. Of course, that's not a very good number, but all other economies are going to be in minus. So therefore, there is going to be a lot of opportunities sector-wise, specific-wise. You'll have to look at the area in which you're talking about. Companies are going to think that they're no longer going to be in Bangalore alone. They need to be in Delhi. And companies in Delhi are going to say that we're not going to be in Delhi alone. They're going to be in Chandigarh, or maybe in also in Chennai or Hyderabad, as the case may be. There is a lot of demand also going to come up. People are going to renegotiate things. There is a lot of opportunity which is going to get floated. And I'm even the $5 trillion economy, I'm not very worried about it. If one of those Indian companies who are working on it comes out with a vaccine, that company by itself will be worth $5 trillion. So we need to think innovatively. If we are able to make, if we are the ones who are going to patent it and create that kind of a vaccine in that short span period of time, then probably Mr. Modi will not have to wait for 2025. You'll have a company listed in the Indian Stock Exchange or the New York Stock Exchange with Indians holding the shares at $5 trillion. I can promise you that can happen. Insofar as demand is concerned, yes, in the immediate terms, it looks like people are going to sit on cash, hold on cash. Nobody's going to buy a house tomorrow. But there are so many people in India who are going to buy a house for the first time. Probably if the interest rates were to come down, as they are likely to, if the money is going to be available, and if quantitative eases are going to be available, and the world is going to be flush with funds, dollar not giving you interest less than 2% on LIBOR, Japan giving you 0% of interest, and if we can make a business case out of it, everybody needs to live in a house. You will require apart from 2-bedroom apartment, you will also require a small study. And I was told Khaitan and company used to give a small what do we say, allowance for having a chamber in the office, chamber at home as well. Historically, maybe that will increase. So therefore, demand is going to increase. We are very hopeful. If we make a mess out of what we are doing, and if we continue to be bureaucratic, it will be difficult. But as I hear, government has been issuing notifications every day in the morning, evening, and afternoon. And if we can iron out certain creases and think that we can do it, the next decade would not that be of China or America, it could be that of India. And if we work with that kind of a mindset, we may have a blip for 6 months, 9 months, but in a history of a civilization, these are in rounding off, it will go off. That's what I believe. So demand will be there. No worries on that.
Thank you for the positive note, Manish.
Of
We
course.
just want to inform our audience that we'll be extending the webinar till 5:45 because we have some more interesting questions to ask our panelists, and we don't want to let them go so soon. So, next question, Dave. You spoke about that working from home. Now, as a legal team, I mean, you are the unenviable and hugely responsible task of managing the legal team of one of the most valuable FMCG companies. So, as a legal team, which area has the firefighting, so to speak, been focused on? Is it compliances, recovery, contractual performance, labor? So, and did you face any challenges on account of working from home and not having access to a fully functional office?
So look, I lead a team of highly business-oriented lawyers, and they are fully integrated with the business. The task before us 6 to 8 weeks ago, when this whole thing began, was to unlock our end-to-end supply chain and our CD, customer development and sales operations. And you all know the number of notifications and the number of orders that were issued from time to time. And there is a full team that works on that, and they informed me that until yesterday, 644 notifications and orders have been issued, which include 93 from center, more than 540 from different states. So decoding those, understanding the impact, applying it on the ground, using them in one state, and if you're effective in one state, citing that in another state, all that was being done by the legal team. The legal team is fully in the thick of things. I start the day with a call in the morning with my team where lawyers from across the country join that call. And then they get into their own leadership team calls. I get into my management team call that is led by Sanjeev. We have a South Asia responsibility, so we have a Asia leadership call. We also look after what happens in the other countries of South Asia. So legal team has been pretty much in the forefront of unlocking our supply chain. And as I said, when this whole thing started, in the very first week, we had virtually no operations. And given that in a FMCG scenario, groceries would typically have a pipeline of about 40 to 45 days from factories to depots to distribution centers. And with panic buying that happened, almost a week's inventory was lost. A week or more than about 10 days of inventory was lost. And given that the very first week you had virtually no operations, it put a lot of pressure. So there was huge demand that we are not able to supply, and that stands pretty much true for the entire industry. And even today, we are supplying not at 100% at all. As I said, it's an ever evolving situation. So the legal function has been in the forefront of all this. They are not into, in addition to this, these are exceptional times when we have all kinds of COVID-related stuff that is going on. But equally, we have our own calendars. So I have a review going on for each vertical that reports into me. We have global calls. We've got our regular reviews that happen. We are a company which looks after a lot of well-being. So we've got a lot of town halls. We have a well-being expert who comes and talks to us. All that stuff goes on. So now it's challenging. It is to your question on working from home. It is challenging. I don't think we've been ever busy that we have been in the last 6 to 8 weeks, but we have been up to it. The best of any company comes out in a crisis, and we are all going behind one big goal to ensure that our consumers get the products that they need on a daily basis. That's our only consideration, and we are all working towards that. So it's been tough, but we've been up to it, and hopefully things will improve from here.
Thank you. Thank you, Dev. Dr. Gimawat, you had mentioned that there is a need for legal and regulatory reforms to give a boost to the infrastructure sector, and why would people want to invest even the domestic sector? So very briefly, if you can highlight what, according to you, are some of the reforms that are required to help the infrastructure sector recover post-COVID?
Well, Vanita, pre-COVID or post-COVID, the fact is the infrastructure sector has not grown in India. Despite of the fact that it's a huge potential, it has not grown up. And I think there are mainly two reasons. One is the legislative part. Of course, legislative part can always be addressed. When industry association, corporates, government, they create public opinion and you legislate accordingly. And that happened in the past. For example, IBC is a true example of that. And similar other legislations also. And there are legislations where the public opinion got framed and legislations got amended and changed. Of course, there were negative side to this also in terms of knee-jerk reaction in some cases, but then legislations are changing. There is no doubt about it as far as industry specific legislations are concerned. And I have my thoughts in terms of there are serious requirement of changes in the power sector, for example, or even the mines and mineral development kind of scenario, the kind of situation which we are having in terms of the mine auction plan, etc. In fact, the Prime Minister yesterday only had a detailed meeting on the mining development plan. He was talking about the additional mining blocks. He was talking about use of modern technology in mining, etc. So the government is taking action on these things in terms of legislative part, in terms of making those changes also in the system. But then what is the problem in terms of why we are not achieving this? That apart from the core sector, the infrastructure sector mainly is dependent on two things. One is the real estate kind of infrastructure, and other infrastructure is basically driven by the government per se, like roads, bridges, railways, ports, etc. Now, there we do not have a successful model. The PPP model, which was introduced a decade back or just 15 years back or so, that model has miserably failed. And why that failed is that once you execute a project under the PPP model, government would be taking a backseat and would only be raising one or the other issues, so that project will not get executed. So the PPP model has completely failed. Now the PPP model failed also because of a few reasons, and also that is the problem in all infrastructure projects also, that we entertain certain issues which we should not have entertained. Projects get delayed. It's not the COVID situation. Projects get delayed in the past also, today also, and perhaps tomorrow also, unless we make those changes in the system. Why projects get delayed? Because there would be one or the other vexatious or frivolous litigations. Those get entertained by the courts. Courts would be passing one or the other interim orders in terms of staying the execution of the project. Those stay of the projects would continue for 2 years, 3 years. We have all seen this. We have all experienced this. Whether that is the Okhla Bird Sanctuary issue or some other NGT related orders or some other orders in terms of staying the whole project. What ultimately happens? Government's exchequer gets impacted. The public would not be getting the return as far as their money is concerned. So everything is getting impacted. So these two systemic issues, in terms of, one is that there's a serious need in terms of coming out with a legislation on vexatious or frivolous litigation that should be stopped completely. These public interest litigation should not be entertained at all as far as the infrastructure projects are concerned, and there should be liability fixed, whoever is filing this, or whenever some interim orders of staying the projects are getting passed. Interim orders are becoming a norm rather than an exception. Now this situation needs to be changed. It needs to be changed. The second important aspect, as I earlier also mentioned, that involvement of the bureaucracy. Again, I am saying this is a very, very serious issue. I'm not talking about the higher bureaucracy. I am talking about the bureaucracy at all levels, from the remote and mufassil areas to the Delhi and Mumbai and those kind of metropolitan cities as well. At all levels, I think the serious change is required as far as mindset is concerned. There should be a mechanism that economic growth is not only for the betterment of those private sector, but it is also for the betterment of everybody, of the nation. That realization needs to come if we want to focus on the infrastructure sector. So the last 7 decades experience, if I talk about the last 7 decades of experience, I think our bureaucracy has been trained under a socialist kind of mindset, and perhaps that is creating a problem. Coupled with this, a socialist mindset of the judiciary. I'm again saying this, and I'm cautious about this fact, that I'm making this a statement, that you should not pass any orders which is having a long-term economic consequences, and definitely you should not invoke Article 142. It is too damaging, because we are not understanding that invocation of Article 142 in one order, how the lower judiciary would be treating this. they would be following the same kind of precedents in the day-to-day kind of orders and judgments, and which is impacting the overall industry. So with this, broad changes as far as the business friendly environment is concerned, I think that is required. One more comment which I would be making before I conclude on this, I know that time is too short. Prime Minister, I think yesterday only said, when he was talking about the plug and play kind of model, that plug and play kind of model, not only this should not be applicable only for those MNCs, to attract those MNCs. The plug and play model should also be available to domestic industry, the domestic entrepreneurs. I think that would make a big change in terms of the economic revival, including in the infrastructure sector. Thank you.
Thank you. Thank you. Manish, as far as the real estate sector is concerned, what according to you, like Dr. Gimawat mentioned about infrastructure sector, the legal reforms, according to you, what changes can the legislature bring about? How do you see also what are the challenges faced in registration, for example, of lease and licenses, especially in clusters like NCR, Mumbai, etc.? So how do you see businesses raising capital, and what do you think that the legislature can do for the real estate sector, legal reforms?
See, all complex problems have very simple solutions. And we must not look at, when we look at these problems, we must not look at the whole country in one length and breadth. We must see pockets of problems and simple solutions. If for Delhi, Bombay, Calcutta, Madras, Chennai, Kolkata, Bangalore, Bengaluru, and your Hyderabad, if you were to e-tize the entire land records just of the 7 cities, where 80% of the transactions in value and volume take place, half the problems with respect to title get solved. If everything, like during this pandemic period itself, during this COVID period itself, Mumbai has started registration of leases electronically. If we could do that, then half your problems insofar as the title, bank financing, everything becomes a lot more easier. Insofar as the approvals are concerned, then the approvals must be looked at from a city level. If the environmental approvals are granted in the master planning itself, and you just have to comply, and those approvals become plug and play, life will become a lot more easier. If title insurance is brought in, then buyer and the seller, large investments, REITs, people will not be worried, because that risk will get shifted to insurance companies, and probably it will make much more sense. If you can have your house property and your real estate which we own in the electronic format, we will be much more happier and safer. Half the problems will get over. And then there are other issues with respect to labor and other health, safety, and other things are there. We must reduce more and more bureaucracy to the extent it is possible, have a can-do attitude, and ultimately real estate sector is going to be the second largest employer after agriculture. So ultimately we must be all welcoming. Probably on the finance side, there is a lot of cheap capital which is available in the world. So therefore, if the interest rates come down, if the buildings are made faster, approvals come faster, title is insured, then this sector will certainly look up and will provide that succor. While we need a $5 trillion company, we also need to ensure that the person earning less than $2 a day gets additional $2. And these $2 are going to only come from infrastructure, construction, and all these small activities. So therefore, these are very small steps. I am not saying which is something which is new, something which the government doesn't know. For 10 years, we have the title insurance bill which is lying. For 10 years, we have been trying to do with the best IT brains in this country. We have not been able to put the entire records in a manner and in a language and in a format that it makes life easy for everybody. If these small steps, which do not require much of a financial stimulus, unlike 1 lakh crore is not required, all that what you need to do is make things more simple. Once that is done, I think the sector will look up. We have 1 billion and more people to feed. Everybody will work in order to make that square meal a day. This economy has to and will certainly develop. And once it develops, there'll be money and opportunity for everybody. So all these complex problems actually have simple solutions. And those solutions have been talked about for the last 20 years or maybe 70 years. Time has come just to pick up them, prioritize, and tick them and do them. That's about it all. Once that happens, we're all happy and done. That's about it. That's a short answer.
Thank you so much, Manish. So I'm afraid we're now out of time. It has been a privilege to share the platform with such esteemed panelists who have given such great insights and solutions. And now we very quickly, we'll just try and take a few questions. So one of the questions that we have had is, given that there is likely to be a gradual opening up of corporate operations, will the unutilized workforce be compensated, and how might those who join work first be determined? So may I request one of the panelists to take up, how do we decide which workforce will join first?
Vanita, you shoot whoever you want us to answer. We are at your service.
Dr. Gabawat, any thoughts?
No, so I'm sorry, I could not get the question correctly or rightly. Just can you please again repeat this? Sorry for this.
Given that there is likely to be a gradual opening up of corporate operations, will the unutilized workforce be compensated, and how might those who join work first be determined?
Well, look, you invite your workforce in a situation where you want to work with a limited workforce and you don't want to, because of the COVID kind of situation, safety safeguard kind of mechanism, you will be inviting your workforce perhaps gradually or in shifts. For example, out of say 100 people, you would be inviting first 50 people on a day, second day another 50 people. If the question is this, that workforce underutilized, then you would be perhaps inviting them in shifts. So this is one option which is always available with you. Having said so, let me also give a perspective here that the way in which, you know, it's a lot of discussion happened as far as the Disaster Management Act is concerned. And I think those apprehensions have also been raised that what would happen if suppose you invite worker, but then the worker is not coming up. Worker is not coming up and he would be making one or the other excuse. So how to disincentivize this kind of situation or incentivize the situation as far as the workers who are coming to your place? So let me make a comment here, is that the law provides, Disaster Management Act provides that so far as there is a lockdown, then if the worker is not coming, you would be making him payment. But then as regards the lockdown is out, operations are continuing, and if suppose there are no genuine reasons of lockdown or COVID kind of disease, etc., then you have all the rights under the labor laws, because labor laws have not been suspended. There is no notification or circular by the government where the labor laws are suspended. So you have all the rights as far as the labor laws are concerned, and you can exercise those rights, whether layoff or retrenchment, etc. It's a legal position which I have communicated on this. But then otherwise, normally it happens is, you always be collaborating in terms of your stakeholders and finding out a solution.
Thank you. Dave, if I may request you to take up this question. There's a question, will the occupier factory manager be liable for any employee contracting COVID-19 after operations are allowed to be resumed by local authorities? Some of your factories have already, they're carrying on operations. So do you think that the occupier factory manager can be held liable?
So I just want to respond in two parts. I just want to also talk about the earlier question. As industry, we have to be fair. There is a humanitarian part of it and there is a legal part of it. I don't think we can get too swayed by the legal part and start raising sections and questions and looking at acts. At the same time, no one would expect that one would continue to get wages and just be at home. You can't create a situation where 50% of the workforce is coming to work and the other 50% is sitting at home and expecting wages to come. So one has to be fair and equitous in this. One has to also invoke regulation where required. And I think there is no ambiguity as far as whatever I've seen within the MHA orders and the state notifications. It's pretty clear that if you are in essential services, essential goods, you have to come and work unless you are in a containment zone. Either the worker is in the containment zone or the factory is at the containment. Then you will be treated to be on duty, right? But you can't be subsidizing for those who don't come to work when they can come to work. The other part which you talked about, occupier being held responsible, I think this will be a disaster. I mean, someone contracts COVID, we don't know from where. You have no idea where he or she contracts COVID and you hold the occupier responsible, that will be wrong. Unless you can show that you did not have social distancing norms at place, you didn't have hygiene norms at place at the workplace, and therefore then you can be treated, you can be seen to be negligent. Everything that comes with from MHA as an SOP. In the health ministry website, if you look at their guidelines and regulations, there's a very detailed SOP. If those are being followed, then I don't think you can hold occupier or manager responsible for someone who may catch COVID. More important would be to ensure that that person is dealt with, he's not socially ostracized and given all the healthcare needs so that the person can recover. Because in most of the cases, people recover.
Thank you. Manish, may I request you to take the last question before we end the webinar? As in certain, there's a question, as in certain cases, provisions of Contract Act do not apply to leases. Can we incorporate a clause similar to material adverse change? Example, no payment in cases where due to any reason, lessee is not able to temporarily make full use of property due to a cause beyond its control.
See, in hindsight, you can do anything. So that is fine. So contractually, you can agree to disagree and agree to provide anything. So contractually, if you have agreed that not able to use for the reasons attributable to the lessor or not use because of any reason whatsoever, assuming that it is an executed contract, it is not an executionary contract. Insofar as the lease is concerned, it is the part of transfer of property. So if I've transferred the property, then you want to fasten more risks. So if both will be conscious, lessor and lessee, we should hope that we get, insofar as we make a fair clause, there may be some periods that you agree that you will, for such period, you will bear the loss. For such period, I will bear the loss. For such period, both will bear the loss. And on the happening of such an event for such long period of time, both will have the right to exit out of it. So you cannot be in occupation of the premises without your permission. I cannot step into the leased premises. That will be trespass. And having given the premises, and I have to also service insofar as LRDs is concerned, and everybody has taken money and everybody has to pay banking and finance. So some equilibrium will come in the society. The manner in which people will understand today, it may be sounding very inequitous that you are not able to use the premises and still have to pay. But that may not be changed, because I have also, insofar as what I get in terms of your lease rental, 80% of that amount I may have already paid. I would have to pay to the banks. And if it is a REIT, then those poor pensioners will not get their pension or the income which is to be derived. So therefore, it is not, some equilibrium will have to be, because ultimately out of these rental incomes in future, what is going to happen? There are going to be REITs, and people like you and me, not you, but maybe people like me and Dave, in the next 20 years, in the next 10 years, are going to get pension out of it. So do you want that situation to happen? So therefore, insurance and equilibrium is the only thing which you'll have to look at it. But individually, it will be a supplier and a supply and demand kind of a situation. If you are in a better bargaining position, you will bargain it out. If you are not able to do so, you will have to live with it. So ultimately, the burden will go to those shoulders who can bear it or who can command it. So therefore, in hindsight today, you can agree to any kind of a clause and get into that situation. But even if you don't have, you are well prepared, you know what is the bargain that you have entered into. People did not realize that insofar as force majeure is concerned, would hit them in this very manner. But such kind of pandemics, if you look at it, happen every 100 years. The last time when we had it was the Spanish flu, which actually happened in 1918. So therefore, but the memories again, as I said, that those who forget history are condemned to repeat it, and therefore people will have learnings, and both lessee and lessors are going to become far more intelligent than what they are. And lawyers, apart from the regular jurisdiction and indemnity clause, will also be fighting for force majeure. Good luck for lawyers. I hope to be on the other side someday, get gain out of it. I don't know, but good for lawyers. It'll be one clause which will be debated and debated very hotly for times to come, unless we have a vaccine for COVID and an insurance for such kind of a situation.
Thank you so much. We're very grateful for your time. And with this, we come to the end of the webinar. Hagrid, do you want to say a few
Very
words?
enlightening comments, I must say, from the panel. And I have to also add that very fair comments, irrespective of what position each one of you is holding. I think the comments have been very fair, very enlightening for, not just, I'm sure, for the audience, but for us as well. Thank you very, very much for your valuable time and your insights.
Thank you.
Very good weeks of
Thank you, sir.
business and law. Thank you.
Thank you, Mr. Khaitan. Thank you, Vanita. Thank you.
Thank you.
Thank you.
Done. Thank you. I'll just see how to log out.
Hi.